Hello, and welcome to this audio lecture on agency law. I'm Professor Seth Oranburg, and today we're going to explore one of the most foundational concepts in business law, agency. This concept lies at the heart of many business relationships and underpins much of what we'll study in this course on business associations. Let's start with the basics. What is agency? At its core, agency is a fiduciary relationship, which means it's a relationship built on trust and accountability that has legal consequences. In an agency relationship, one person, called the agent, has authority to act on behalf of another person, called the principal. The key here is that the agent's actions can create legal obligations for the principal. This is why agency law is so powerful and so important to understand. The third restatement of agency defines agency in a very precise way. According to section 1.01, agency is, and I quote, the fiduciary relationship that arises when one person, a principal, manifests assent to another person, an agent, that the agent shall act on the principal's behalf and subject to the principal's control, and the agent manifests assent or otherwise consents to so act, end quote. That definition highlights three essential elements of agency: consent, control, and acting on behalf of the principal. These elements are what distinguish agency from other types of relationships, like simple contracts or partnerships. So let's break these elements down. First is consent. For an agency relationship to exist, both the principal and the agent must agree to it. Now, this doesn't mean there has to be a formal contract. Consent can be implied through actions, and it may be binding even if it wouldn't be enforceable as a contract as a matter of law. For example, if a business owner allows an assistant to negotiate contracts on their behalf, and the assistant does so with the owner's knowledge, that's consent. Consent can be explicit or implicit, but it has to be there. The second element is control. The principal must have the right to direct the agent's actions. This doesn't mean the principal has to micromanage the agent, but there must be a clear line of authority. For example, if a real estate agent is negotiating the sale of a property, the property owner, as the principal, has a right to set boundaries, like the minimum acceptable price. That's control. Finally, the third element is acting on behalf of the principal. This means the agent's actions are intended to benefit the principal. They can't benefit the agent themselves. There's a duty of loyalty. For example, a corporate officer negotiating a contract is doing so to further the interests of the corporation, not their personal goals at the corporation's expense. If the agent's actions are primarily self-serving, that relationship likely is an agency and may violate what we'll call fiduciary duties that we'll discuss later. So why does all of this matter? The answer lies in accountability. Agency law determines when a principal is legally responsible for the actions of their agent. For businesses, this can mean the difference between successfully delegating tasks and being held liable for actions they didn't explicitly authorize. Let's consider a hypothetical scenario. Imagine a company hires a manager to oversee purchasing. The manager signs a contract with a supplier, but it turns out the manager's authority was never formally approved by the board of directors. If the supplier reasonably believed that the manager had authority to sign that contract, the company, as the principal, is probably still bound by it. That's the power of agency law. It protects third parties who reasonably rely on what we'll call apparent authority. But it also ensures that principals and agents operate within clearly defined boundaries, with duties to each other. As we move through this module, you'll learn about different types of authority, actual and apparent, and how they affect the principal-agent relationship. You'll also explore the fiduciary duties agents owe to their principals and the way agency relationships can be terminated. There are also consequences of failing to notify third parties when those relationships end. Agency law is everywhere. It governs interactions between employers and employees, real estate agents and property owners, and even attorneys and clients. By understanding the principles of agency, you'll be equipped to navigate complex business relationships and anticipate legal challenges before they arise. In the next lecture, we'll dive deeper into the concept of authority, focusing on the difference between actual authority and apparent authority, and why those distinctions matter. But for now, take a moment to reflect on the scope of agency in your life and think about the examples you've encountered in your own experience. Maybe you haven't used this term, but perhaps you've been an agent yourself, or you've acted as a principal, commanding and controlling someone else's behavior, who you trusted to act in your best interests. How did those relationships function? Were they built on trust, control, and mutual understanding? If they went wrong, were you aware of what legal recourse you had? For now, thank you for joining me in this introduction to agency law. I'll talk to you in the next lecture.